Today, the CFTC reveals most of its whistleblower tips involved digital assets. PayPal registers as a crypto service provider in the UK, and former federal prosecutor Brendan Quigley weighs in on the latest in the SBF trial now that closing arguments are underway. Welcome to CNBC's Crypto World. I'm Talia Kaplan. Crypto prices pretty much flat this morning. At noon Eastern, Bitcoin traded right around $34,300. Ether hovered at $17.92 and XRP still traded around 60 cents. Okay, let's talk about the top stories. The CFTC revealed that the agency paid out $16 million to whistleblowers this year, and most of the tips involved crypto. In a statement published on the CFTC's website, Commissioner Christy Goldsmith-Romero stressed that crypto is an area that continues to have pervasive fraud and other illegality. She went on to point out that with the rise of crypto, more retail customers have come under the CFTC's jurisdiction, making even more critical the efforts of its whistleblower program and the Office of Customer Education and Outreach. As many of you know, the CFTC and the SEC have been engaged in a turf war of sorts over regulatory oversight of cryptocurrencies right here in the U.S. Next, PayPal has registered with the Financial Conduct Authority as a crypto service provider. That's according to the UK regulator's website. But PayPal faces some limitations. Those include offering staking services to customers and allowing participation in initial coin offerings. Now, in August, Reuters reported that PayPal would temporarily pause the ability for UK customers to buy crypto assets on its platform, saying that the company was working to comply with new regulations around advertising crypto. That same month, the global payments giant also launched their US-backed stablecoin. And finally, let's talk about the latest in the Sam Bankman-Fried trial. Yesterday, SBF finished his testimony in which he responded to questions with "I don't recall" more than 100 times. Now we're on to closing arguments, starting with prosecutors. The government doubled down on its claim that SBF gave special permissions to Alameda that allowed the trading firm to steal customer funds. Assistant U.S. Attorney Nicholas Roos alleged that the former FTX CEO knew that it was wrong, and that's why he kept it so secretive. The prosecutors also pointed to a moment during his testimony where he admitted to knowing about Alameda's code change, which exempted the crypto hedge fund from auto liquidation. Then they laid out why they believe SBF was the only person who had motive for the alleged crimes. Prosecutors argued that Caroline Ellison, the former CEO of Alameda, never worked at FTX and didn't have access to computer code. They also said Gary Wang and Ishad Singh had no involvement with Alameda, though we should note Wang did have a stake in the firm. On top of that, it was revealed in court that Bankman-Fried was the one who signed for the setup of the North Dominion bank account. That's where FTX customer money was deposited into Alameda's bank accounts. Prosecutors also reminded the court that all three co-conspirators testified that SBF knew about the $10 billion hole in the balance sheet. Now, later today, the defense will move on to its closing arguments. Jury deliberations could begin Thursday afternoon. All right, as the trial of SBF winds down, I spoke with Brendan Quigley, former assistant U.S. attorney and partner at Baker Botts, to get his take on Bankman-Fried's testimony, closing arguments, and more. During his testimony, Sam Bankman-Fried blamed top lieutenants for troubles at FTX. He also told jurors that he didn't commit fraud and that he thought the crypto exchange's outside expenditures came out of company profits. The former FTX CEO said he relied on the advice of the firm's in-house and outside counsel to make business decisions like deleting signal messages and making loans to himself. It's important to note that when he was asked for details about the claim, he said he couldn't recall. We spoke with you as SBF was starting to testify at his trial, but now that he's done, what do you make of his argument that the lawyers were mostly to blame?
Yeah, I think a couple of things. As I said when I was on before, an advice of counsel defense is a very difficult defense to carry the day before a jury, particularly in a case as sprawling as the SBF case. Right? It's not an instance of filing one tax return or one document with the government. Ultimately, you can't blame the lawyers for everything. You blame them for some things, but not for everything. And I think the government was able to do a effective job, just from reading it, at least from the news coverage, of cross-examining him based on his prior statements in the media. And I think that was probably pretty effective.
Let's focus on that apparent strategy from SBF to respond to prosecutors' questioning with "I don't recall" more than 100 times. How effective is that tactic? How does that impact his case and his credibility with the jurors?
Yeah, I think what I would expect the prosecution to do in closing is they'll probably put up. I mean, there's no video in a federal criminal trial, but you probably could find the transcript and have some type of slide deck or demonstrative or something like that, listing all the times he said I don't recall and all the things I don't. He said I don't recall too. And I think that likely has an impact on the jury, and particularly if they can contrast that with things that he did recall, and you say, ladies and gentlemen, he recall this, this, and this, but he couldn't recall these other things.
Now, today, we're moving on to closing arguments, starting with the prosecutors. They're making the case that SBF is the only one who had motive to commit the alleged crimes. Prosecutors argued that other former executives had no involvement with Alameda and that Caroline Ellison didn't have access to computer code. What do you make of the prosecutors' arguments? Is that common practice to isolate the defendant from the co-conspirators who have already pleaded guilty?
Yeah, it can be a bit tricky because under the law, the jury's not allowed to consider that the other co-conspirators pled guilty. That's an individual decision by them. The jury will be instructed by the judge on that. So you can't put too much weight in the guilty pleas themselves. However, you can point to his role as a leader and the fact that they were doing things, or they testified they were doing things in his direction.
In a nutshell, what do you make of SBF's testimony during his trial? Is there anything that stood out to you?
I think it was unique in a criminal trial because, unlike a civil case, in a criminal case, usually you don't have depositions, you don't have discovery, things like that, or you have discovery, but it's more limited than a civil case. Here, by contrast, again, unlike most criminal cases, there was a large body of prior statements that the witness or the defendant in this case had made, which is very unusual. And I think, again, the prosecution, I'm sure they spent hours poring over those interviews and videos and kind of organizing them by topic and every time he tried to find any contradictions, either between those statements to the media or between those statements to the media and his trial testimony on direct. So I think that I think made it unique for the prosecution and for the defense, that there was a lot out there that ordinarily in a criminal case you wouldn't see.
How do you think his testimony will impact his case? Usually, lawyers recommend that the defendant does not testify at their own trial. So, what do you think will happen now that SBF took the stand?
Yeah, I mean, I think it is a more personal for the jury, right? The case is soon to be in the hands of the jury. For the jury, it's a lot more personal decision. Even it's you're not just judging the guilt of somebody who's been sitting there in silence at a table the whole time. It's somebody who you actually heard from for days. And I think that depending on the witness, depending on the juror's sympathies, depending on how the testimony came in the abstract, that can cut either way.
As you pointed out, next we head to jury deliberation. Do you have any expectations for how long that could take and what the outcome could be? If SBF is convicted, how much jail time are we talking about here? He could potentially face the rest of his life behind bars. But do you think that will really happen?
Yeah, look, both those things, his eventual sentence and then before that, the outcome, right? Are difficult to predict. I mean, I've had juries out a couple hours, I've had juries out many days, and when I was a prosecutor, and in both sets of those cases got convictions. And I think in some ways, the amount of evidence in this trial was a lot. In some ways, that cuts both ways, right? I mean, the jury might get back there and they might say, "We've heard enough already. Let's just vote and go home." Or they might say, "Look, he is looking at a lot of jail time." They're not supposed to consider the amount of jail time he was facing. They don't even really technically aren't supposed to know that, but I'm sure they can infer that. And they might say, "Look, he is looking at a lot of jail time. Let's go through this kind of methodically and make sure." So it's tough to tell. I mean, again, you could see it. You could see it being a very short deliberation. You could see it being a long deliberation. It's really up to the kind of how the jurors feel about the case and how all 12 of them. I mean, we always said as a prosecutor, it's hard to get 12 New Yorkers to agree on anything. much less whether a defendant is guilty beyond a reasonable doubt. So it is a bit of a miracle that they do almost always reach a unanimous verdict. So
That's a very astute point. How much time do you expect SBF could face behind bars? Do you really think it will be the rest of his life?
yeah, I mean, look, his guidelines range, which is the range that the judge, if he was convicted, I think would be close to very, very high. I mean, probably approaching several decades, if not not a life sentence. Again, I think a lot depends on if he is convicted, and he's not been convicted yet, right? So I think the judge has a tremendous amount of power in sentencing, right? And I think a lot of this will depend on how Judge Kaplan views the case, how he views SBF, how he views any mitigating circumstances. I mean, even if an advice of counsel defense is not enough for the jury, will it sway the judge some way? Are there, are the victims of the offense perceived as being sympathetic? I mean, all those things can kind of weigh into the judge's decision making. I think I've never been a judge, but I've heard from judges that sentencing the defendant is the hardest thing that they have to do because it is such a weighty choice, particularly in a case, assuming he's convicted, which he hasn't been yet, right? Like this.
Okay, that's all for Crypto World today, but we'll be back again tomorrow, and we'll see you then.